Hi, this is J. Sai Deepak. I am a senior associate at Sai Krishna and Associates. I have been litigating with Sai Krishna and Associates for the last 5 years before the Delhi High Court, the Intellectual Property Board, and the Indian Patent Office. The module that I will be speaking on at this point is Patentability of Computer Programs, its position under Indian law. Article 27 of the TRIPS is the first provision that needs to be looked into to understand the obligations and flexibilities that are available to member states in terms of the subject matter that may be allowed or that may subject matter for which patents must be granted, and subject matter that may be excluded from the scope of patentability. Specifically, the provision that needs to be looked into would be Articles 27.2 and 27.3. 27.2 and 27.3 permit member states to exclude subject matter such as diagnostic methods, methods of treatment, inventions relating to the treatment of plants, animals, so on and so forth. Specifically, Article 27.2 permits member states to exclude subject matter from the scope of patentability on grounds of morality and public order. It is an exercise of this flexibility that is provided under Article 27.2 of TRIPS that India chose to exclude computer programs and several other subject matter from the scope of patentability, and this was introduced through the 2002 amendment to the Indian Patents Act of 1970. The provision that we will be discussing at this point is Section 3K of the Indian Patents Act, which excludes from the scope of patentability computer programs, algorithms, and business methods. It is clear from the language of the provision, which is Section 3K, that the provision strikes a distinction between computer programs per se and algorithms. Based on a layman's understanding and also an understanding of a practitioner of computer programs or that particular technology, it could be said that an algorithm is merely a sequence of steps to perform a particular process or to achieve a particular result. In stark contrast, when there is a reference to computer programs per se refer to the execution or the adoption of that particular algorithm in a computer understandable language or in such as Java, so on and so forth. The question that needs to be asked is, as opposed to specifying computer programs, is there a reason that the provision restricts itself to computer programs per se? The answer to this question must be found or is to be found in the Patents Amendment Bill of 1999, where the reference was restricted to computer programs, but it was narrowed down further in the final version of the bill to computer programs per se. What was the intent behind such restriction? What was the what is the import or interpretation of computer programs per se? Unfortunately, we do not have case laws identifying or explaining this particular aspect of the provision. The only two decisions that are available under the Indian law at this point is the decision of the Controller of Patents in Yahoo versus Rediff.com, which was then appealed against by Yahoo before the Intellectual Property Appellate Board, but to no avail. The Controller of Patents in this particular case dismissed the patent application of Yahoo in a pre-grant opposition that was filed by Rediff.com. And one of the grounds for dismissal of the patent application was that it attracted the prescription of Section 3K. It must be borne in mind that the dismissal of this particular patent application was on the basis of the fact that, according to the Controller of Patents, the subject matter that was claimed was more of a business method, and therefore there was not much of a discussion on what is a computer program per se within the meaning of Section 3K. Similarly, there was no discussion on computer programs before the Intellectual Property Appellate Board. The reason it is necessary to understand or read these two decisions in the context of patentability of computer programs is this. On one hand, the Controller of Patents chooses to look at subject matter eligibility under Section 3 of the Patents Act before proceeding to issues such as novelty, non-obviousness, and industrial application. On the other hand, the Intellectual Property Appellate Board goes on to discuss grounds of novelty and obviousness before discussing the issue of Section 3K. Now, this shows two distinct approaches and two diametrically different approaches for one good reason. If Section 3 is meant to filter the subject matter that may be permitted in a patent application, In other words, if it is the test to understand what is eligible subject matter under Indian law, then section 3 essentially acts as a filter, and therefore it is necessary to examine a patent application primarily and firstly through the lens of section 3 before you go on to test its patentability on the anvils of non-obviousness, inventive step, novelty and industrial application. Therefore, to the extent that the controller chooses to look at the application primarily on the basis of section 3K before proceeding to test it on the other criteria of patentability, in my humble opinion, this would be the better approach compared to the IPAB's approach. Even in the IPAB's decision, wherein the final decision of the controller of patents was ultimately upheld, the IPAB itself contradicts itself in two different situations. In the first introductory portion of the decision, the IPAB takes the view that novelty and obviousness must be first of all looked into before section 3K or patent eligibility is examined through the lens of section 3K. However, in the later portions of the decision, the IPAB takes a completely different view, which is consistent with the controller's approach, which is to say that so long as the controller of patents is in a position to come to the conclusion that the subject matter claimed attracts any of the provisions of section 3, there is absolutely no need to get into an inquiry on the issues of novelty, obviousness and industrial application. The sum and substance of this is this: if section 3K is meant to be the first line of defense in giving effect to public policy, in giving effect to India's take on what is patentable under under the law of this particular country, then section 3 must be the first point of inquiry before other aspects are looked into. Now the point is, although this helps us understand how section 3 and the other criteria interplay with each other, both these decisions do not shed any kind of light on what is the meaning of computer programs per se. Let us proceed with an analysis of what is the meaning of per se in plain and simple English. Per se simply means as such or by itself. In other words, computer programs by themselves are not patentable in this country. If computer programs by themselves are not patentable, it gives rise to two questions. What is the meaning of computer programs by themselves, and what is the meaning of computer programs in the absence of the use of the word per se? Since we do not have judicial guidance on this aspect of the issue, we could take some kind of support or draw support from legislations or provisions in foreign patent legislations which are in pari materia to the Indian provision. The first provision that I think merits scrutiny is Article 52 of the European Patent Convention.